Chair, I'm Cromwell Komu, Principal Economist, National Treasury.
John Kipukel, National Treasury, Economist.
Chair, I am Godfrey Mugwemi, Senior Economic Policy Analyst, National Treasury.
Chair, I'm Angela Mary from the National Treasury. Thank you.
Chair, I'm Bernard Apind, Principal Economist, National Treasury.
Thank you, Waziri. Now, let me have the Vice Chair introduce herself.
Thank you, Chair. Good afternoon. Marianne Ketany, MP Aldai Constituency, Vice Chair to this committee. Thank you.
Now, Waziri and the team from Treasury, Waziri, we invited you through our letter dated 9th July. That's a follow-up letter after we had done a postponement of the meeting that we were supposed to hold. And in the letter, we specifically asked you for certain information, which we expect to have response from you. This include, number one, the law and criteria that were used in exempting Mombasa Sugar Refinery Limited from paying the import declaration fee in the railway development levy on the raw sugar consignment that we are doing inquiry on. Number two, the revenue that the government has foregone due to tax exemption or waivers on the raw sugar consignment. Number three, whether the National Treasury conducted any cost-benefit analysis before approving the tax waivers on the raw sugar consignment. Four, how the National Treasury will monitor if the intended economic benefits of the tax incentives are achieved. And five, physical measures that the National Treasury has put in place to support local sugar manufacturers. Six, whether the National Treasury has reviewed the impact of existing tariff policies in protecting the local sugar industry. Seven, now that the National Treasury coordinated the KRA, State Department for Agriculture, State Department for Industry, State Department for Trade, KEPS, KEFIS, and the agencies in managing the importation of the raw sugar. Number eight, oversight mechanism that the National Treasury has put in place to ensure that duty exemption on the raw sugar are not abused. Number nine, how the National Treasury will ensure that the raw sugar is used for its intended purpose. 10, how Kenya's regional and international trade obligations influence the National Treasury's fiscal policy on the raw sugar consignment. 11, to provide a list of import duty exemptions, waivers, or remissions granted for sugar imports in the last 5 years. 12, any caps in the current legal framework governing tax incentives and import duty exemption in the sugar sector. 13, to produce any approvals for tax exemption on the raw sugar, gazette notices authorizing exemptions or fiscal incentives, cost benefits analysis supporting the approval of the waivers on the raw sugar, all correspondence on raw sugar consignment, and minutes of all meetings on the raw sugar consignment. And lastly, any other information on the matter under discussion that the Cabinet Secretary may wish to share with the committee. I think we shall start at that. Waziri?
Yeah.
Address the following, then we see how we proceed from there.
Thank you very much, Mr. Chairman, and thank you for inviting me to respond to issues that the committee had concerns with. First, Chairman, you'll allow me to give some background, and I want to just go ahead and start by saying that this submission is made to this committee, which is the Departmental Committee on Trade, Industry, and Cooperatives of the National Assembly, in response to the issues raised in the invitation letter, which I've referenced and dated 9th of July 2026. inviting the Cabinet Secretary for the National Treasury to a meeting with the committee to deliberate on the importation of raw sugar into the country. Kenya's requirements for food-grade and pharmaceutical-grade industrial sugar had largely been met through imports of finished products. So in 2014, Kibos Sugar Refinery Limited constructed a refinery with an annual processing capacity of approximately 150,000 metric tons to support local manufacture and value addition, to respond to the fact that we have largely depended on imports of finished products. But its utilization was constrained by the limited availability and comparatively high cost of suitable raw sugar within Kenya and the East African community. The establishment of the refinery, therefore, presented an opportunity to support the growth of domestic industrial sugar manufacturing by facilitating access to the requisite inputs and raw materials. So in 2023, the Ministry of Agriculture and Livestock Development recommended the importation of raw sugar for local refining. The proposal was subsequently considered through interagency consultations involving the ministries responsible for agriculture, industry, the National Treasury, and East African Community Affairs, culminating in a 2024 proposal to establish an East African Community Duty Remission arrangement for raw sugar used in the manufacture of industrial sugar. So as part of the due diligence process, the proposal was considered through correspondence and interagency consultations involving the ministries responsible for agriculture, industry, and the National Treasury. Further information was sought and assessed on the proposed quantity and source of the raw sugar, the intended market, expected economic benefits, compliance with applicable laws, and measures to mitigate the risk of diversion. The assessment considered whether facilitating access to raw sugar would support utilization of installed refining capacity, domestic manufacture and value addition, employment and skills development, availability of industrial sugar to local manufacturers, and reduce reliance on imports of finished industrial sugar. The consultations culminated in approval of import duty remission under the East African Community Customs Framework through the East African Community Legal Notice, which I have referenced there, dated 18th April 2025. The legal notice actually authorized Mombasa Sugar Refinery Limited to import 165,000 metric tons of raw sugar for industrial use at an import duty rate of 10% for 12 months for the manufacture of food grade and pharmaceutical grade refined white sugar. Following the relocation of the refinery from Kisumu to Mombasa, Kibos Sugar Refinery Limited changed its name to Mombasa Sugar Refinery Limited. Therefore, through a letter which I've referenced but dated 23rd of June 2025, the company requested exemption from import declaration fee and railway development levy on raw sugar imported for processing into sugar for industrial use. The exemption was approved on public interest grounds as a complementary investment support measure intended to facilitate local manufacture of industrial sugar. The exemption was conditional upon the imported raw sugar being refined into sugar for industrial use. Where that condition was not complied with, the exempted import declaration fee and railway development levy, together with the applicable penalties and interest, would become due and payable. So the policy process, therefore, progressed from identification of the need for local manufacture of industrial sugar through sectoral and interagency consultations to approval of the requisite regional and domestic fiscal measures. This provided a basis for the operationalization of domestic capacity for refining raw sugar into food grade and pharmaceutical grade industrial sugar. The specific issues raised by the committee are therefore addressed as below. So the first issue that specific response that this committee required me to address myself to was the law and criteria that were used in exempting Mombasa Sugar Refinery Limited from paying the import declaration fee and the railway development levy on the raw sugar consignment. So this is my response, Mr. Chairman. The exemption from import declaration fee and railway development levy was granted pursuant to paragraph Roman 26 of Part A and paragraph 10 of Part B of the second schedule to the Miscellaneous Fees and Levies Act, respectively. The provisions empower the Cabinet Secretary to exempt goods where the exemption is considered to be in the public interest or is intended to promote an investment whose value is not less than Kenya shillings 5 billion. In the case of Mombasa Sugar Refinery Limited, the exemption was granted under the public interest criterion. The decision took into account the application by Mombasa Sugar Refinery Limited and further the recommendations of the Ministry of Agriculture and Livestock Development and the Ministry of Investment, Trade and Industry, and the anticipated benefits of supporting domestic refining of industrial sugar. So it is not just the request from Mombasa Sugar Refinery Limited that engineered the Cabinet Secretary and National Treasury to approve the exemption, but also because there was strong recommendation from the state departments, that is Ministry of Agriculture and Livestock, and also Investment, Trade and Industry, and that is the practice. So the principal considerations included domestic value addition, utilization of installed refining capacity, provision of a local source of industrial sugar, employment and skills development, and improved competitiveness of locally manufactured industrial sugar. The approval was limited to import declaration fee and railway development levy and was subject to the condition that the raw sugar be refined into sugar for industrial use. If the approved end use was not observed, the exempted levies together with applicable penalties and interest would become due and payable to the Commissioner. And of course the letter that is approving that is annexed. That's approving the two levies from exemption. The second question was the revenue that the government has forgone due to tax exemptions or waivers on the raw sugar consignment. The Kenya Revenue Authority estimated the revenue forgone from the exemption from import declaration fee and railway development levy at Kenya shillings 104,090,404, comprising 57,828,002 shillings in import declaration fee and a further 46,262,402 in railway development levy. Now, the other issue that the committee wanted me to respond to is whether the National Treasury conducted any cost-benefit analysis before approving the tax waivers on the raw sugar consignment. The decision was informed by a qualitative assessment of the identifiable fiscal cost against the anticipated public interest benefits of supporting domestic manufacture of industrial sugar. The fiscal cost comprised the revenue forgone from exemption from import declaration fee and railway development levy amounting to 104,090,404. But the anticipated benefits outlined in their letter included: 1, creation of direct and indirect employment opportunities; 2, transfer of knowledge and technical skills; 3, utilization of installed domestic refining capacity; 4, local value addition through refining of raw sugar into industrial sugar; 5, provision of a local source of industrial sugar for pharmaceutical, confectionery, beverage, and other manufacturers; 6, reduction of reliance on imports of finished industrial sugar; 7, positioning Kenya as a potential regional source of food-grade and pharmaceutical-grade industrial sugar; and finally, support for the manufacturing and value addition objectives of the government. The broader benefits were expected to accrue progressively as the refinery commenced and expanded its operations. On balance, the anticipated public interest benefits were considered sufficient to justify the limited and conditional exemption. The other issue that I was required to respond to was how the National Treasury would monitor or will monitor if the intended economic benefits of the tax incentives are achieved. And this is my response. The immediate objective of the incentive was to facilitate domestic refining of raw sugar into industrial sugar. Monitoring, therefore, initially focused on the movement, custody, processing, and utilization of the imported raw sugar to ensure that it was delivered to the refinery, processed for the approved purpose, and not diverted into the domestic market. A multi-agency team led by the Kenya Sugar Board was established to determine the conditions for release of the consignment, establish monitoring arrangements, and oversee its utilization. The team comprised the relevant institutions responsible for regulation of the sugar sector, customs administration, standards, industry, and security. The wider economic benefits, including capacity utilization, employment, skills development, domestic supply of industrial sugar, and reduced importation of finished industrial sugar, accrue progressively and may be assessed through production, employment, sales, tax, and trade data over the operational period of the refinery. The other issue was fiscal measures that the National Treasury has put in place to support local sugar manufacturers. And this is my response, Mr. Chairman. Fiscal measures have been put in place to reduce the cost of sugarcane production and support the competitiveness of locally manufactured sugar. Transportation of sugar is zero-rated for value-added tax, while fertilizer and qualifying agricultural inputs are exempt from value-added tax. Government also provides subsidized fertilizer to support sugarcane production and improve the supply of cane to local farmers. 2, local sugar manufacturers are further protected against imported sugar through an import duty of 100% or 460 per metric ton, whichever is higher. Excess duty of 40 shillings per kilogram or imported sugar. Import value added tax of 16%, import declaration fee of 2.5%, and railway development levy of 2%. Collectively, these measures increase the landed cost of imported sugar and enhance the competitiveness of locally manufactured sugar. 3, manufacturers also benefit from investment deductions and capital allowances under the Income Tax Act in respect of qualifying investments in buildings, machinery, and other capital assets. These allowances reduce taxable income over the applicable period and consequently lower the income tax burden associated with the establishment or expansion of manufacturing operations. And finally, the legal framework governing imports, declaration fee, and railway development levy also permits the Cabinet Secretary to exempt goods where the exemption is in the public interest or is intended to promote an investment whose value is not less than 5 billion shillings. This provides a mechanism for targeted support where the wider economic benefits of domestic manufacturing and value addition justify relief from the levies. In the case under consideration, the exemption was granted under the public interest criterion. The other issue was whether the National Treasury has reviewed the impact of existing tariff policies in protecting the local sugar industry. And this is my response. The National Treasury periodically reviews domestic tax and customs policies as part of the annual budget process, taking into account revenue performance, sector development, competitiveness of domestic industries, consumer welfare, and Kenya's regional trade obligations. Domestic tax measures are reviewed through the national budget process, with approved changes implemented through the Finance Act and other relevant tax legislation. Custom tariff measures are reviewed through the East African Community Regional pre-budget process and implemented through the decisions of the East African Community Council of Ministers and the applicable ESC custom instruments. The fiscal measures applicable to the sugar sector are therefore subject to periodic review to assess whether they continue to provide appropriate protection to local manufacturers, support domestic production, and remain consistent with Kenya's regional obligations. Where gaps or unintended effects are identified, appropriate legislative, tariff, or administrative changes are considered through the relevant national or regional processes. The other issue was how the National Treasury coordinated with the KRA, State Department for Agriculture, State Department for Industry, State Department for Trade, KEBS, KEFIS, and other agencies in managing the importation of the raw sugar. Coordination occurred through correspondence among the relevant ministries, interministerial consultations, consideration of the import duty remission through the East African Community process, and subsequent interagency consultations on the release and utilization of the consignments. The Ministry of Agriculture and Livestock Development provided the sectoral assessment and recommendation on the availability and stability of raw sugar for local refining. The Ministry of Investments, Trade and Industry provided the industrial policy perspective and initiated the request for consideration of a regional duty remission arrangement. The National Treasury considered the fiscal measures while the Kenya Revenue Authority administered the customs and revenue aspects of the importation. The Kenya Bureau of Standards addressed conformity with the applicable product standard, while the Kenya Sugar Board provided regulatory oversight over the sugar sector and the intended processing of the raw sugar. Other agencies were incorporated into the coordination and monitoring arrangements in accordance with their respective mandates. An interagency meeting was held on 23rd, which I chaired. The National Treasury was held on the 23rd of February 2026 to consider the classification, applicable standards, conditions for release and monitoring of the consignment. The meeting agreed that the Kenya Sugar Board would oversee the utilization of the imported sugar and that a multi-agency team would be constituted to establish the release and monitoring arrangements. The other issue was oversight mechanisms that the National Treasury has put in place to ensure that duty exemptions on the raw sugar are not abused. And this is my response, Mr. Chairman and honorable members. The oversight arrangements comprised the conditions attached to the exemption, customs controls administered by the Kenya Revenue Authority, regulatory supervision by the Kenya Sugar Board, and interagency monitoring through the multi-agency team. The Kenya Sugar Board was assigned responsibility for overseeing and monitoring the imported sugar to ensure that it was utilized for further processing and was not diverted for another purpose. The multi-agency team was mandated to determine the conditions under which the consignment would be released, establish appropriate monitoring mechanisms, and submit 2 interim reports and a final report on its work. The approval further provided that where the raw sugar was not refined into sugar for industrial use, the exempted import declaration fee and railway development levy, together with applicable penalties and interest, would become due and payable. This provided a direct fiscal consequence for non-compliance with the approved end use. How the National Treasury will ensure that the raw sugar is used for its intended purpose. This is my response. The approved purpose of the consignment was refining into food grade and pharmaceutical grade industrial sugar. Compliance was to be ensured through controls over the release, movement, custody, processing, and utilization of the imported sugar, raw sugar. The Kenya Sugar Board was mandated to oversee the utilization of the consignment, while the multi-agency team was required to establish the conditions for release and appropriate monitoring mechanisms. The Kenya Revenue Authority retained responsibility for the applicable customs controls and enforcement of the conditions attached to the fiscal treatment of the consignment. The requirement to recover the exempted import declaration fee and railway development levy, together with penalties and interest where the raw sugar was not refined into industrial sugar, provided an additional safeguard against diversion or use for a purpose other than that approved. Now, the other issue was how Kenya's regional and international trade obligations influence the National Treasury's fiscal policy on the raw sugar consignments. Import duty on goods entering Kenya is administered within the East African Community Customs Union framework. The remission applicable to the raw sugar was therefore considered and approved through the East African Community Customs process. EAC legal notice number that is stated there, which is dated 18th of April 2025, was issued pursuant to Section 140 of the East African Community Customs Management Act of 2004 and Regulations number 3 and 6 of the East African Community Customs Management Duty Remission Regulations 2008. It authorized the importation by Mombasa Sugar Refinery Limited of 165,000 metric tons of raw sugar at a duty rate of 10% for 12 months. Processing the remission through the East African Community Framework ensured that the measure was implemented in accordance with the regional customs regime, and the exemption from the import declaration fee and railway development levy was subsequently considered under Kenya's domestic legislation as a complementary fiscal measure. I was also required, Mr. Chairman, to provide a list of all import duty exemptions, waivers or remissions granted for sugar imports in the last 5 years. The following import duty exemptions and remissions were granted in respect of sugar imports during the 5 years preceding the current inquiry. Number one, there is a Gazette Notice number 10358, dated 9th August 2023, issued pursuant to Section 114(2) of the East African Community Customs Management Act 2004, read together with item 20 of Part B of the 5th Schedule to the Act, authorized the duty-free importation of 290,000 metric tons of white or brown sugar on or before 30th of December 2023. The measure was intended to address the sugar crisis notified by the Cabinet Secretary for Agriculture and Livestock Development. That second one is the EAC legal notice number. It is stated there, dated 18th of April 2025. It authorized Mombasa Sugar Refinery Limited to import 165,000 metric tons of raw sugar for industrial use at an import duty rate of 10% for 12 months. These two measures were distinct. The 2023 exemption was a temporary national intervention intended to address a sugar supply crisis, while the 2025 remission was a manufacturer-specific measure intended to facilitate domestic refining of raw sugar into industrial sugar. The 2025 remission was the first import duty remission granted for raw sugar during the period under review. So the committee also asked if there is any gaps in the current legal framework governing tax incentives and import duty exemptions in the sugar sector. And this is my response. The existing legal framework provides the statutory authority for granting and administering tax incentives and import duty exemptions, including the imposition of conditions and recovery of taxes, penalties, and interest where the applicable conditions are not complied with. Number two, consideration of the consignment highlighted the need for continued clarification and alignment between customs tariff classification and the standards used to determine the nature and intended use of different categories of sugar. The interagency meeting, which was held on 23rd of February 2026, agreed that the matter would be addressed among the relevant government institutions. The National Treasury reviews the tax policy and legal framework annually through the national budget process and the East African Community regional process. Domestic tax provisions are reviewed through the Finance Bill process, with approved amendments enacted through the Finance Act, while customs measures are reviewed and implemented through the relevant East African Community legal instruments. Where implementation reveals an ambiguity or gap, the necessary legislative, regulatory, or administrative measures are considered through the applicable process. The other issue that I was also required to respond to was to produce all approvals for tax exemptions on the raw sugar, Gazette notices authorizing exemptions of fiscal incentives, cost-benefit analysis supporting the approval of tax waivers on the raw sugar, all correspondence on the raw sugar consignment, and minutes of all meetings on the raw sugar consignment. The following documents relating to the application, consideration, approval, and administration of the fiscal measures are attached. Number one is the letter, which is dated 23rd June 2025, from Mombasa Sugar Refinery Limited, requesting exemption from import declaration fee and railway development levy on raw sugar imported for processing into sugar for industrial use, together with the supporting importation documents annexed to number one. The second one is the letter from the Ministry of Agriculture, which is dated 6th February 2024, from the Ministry of Agriculture and Livestock Development regarding the request by Kibos Sugar Refinery Limited to import sugar from the world market for refining, annex number 2. The third one is a letter dated 18th July 2023 from the Ministry of Agriculture and Livestock Development recommending approval for the importation of 100,000 metric tons of raw sugar for refining under annex number 3. The fourth one is a letter dated 13th May 2024 from the Ministry of Investments, Trade and Industry requesting initiation of an East African Community duty remission arrangement to support industries refining raw sugar into industrial sugar, annex number 4. Number 5, East African Community legal notice dated 18th April 2025, approving import duty remission for Mombasa Sugar Refinery Limited to import 165,000 metric tons of raw sugar for industrial use at an import duty rate of 10% for 12 months. Annex number 5. Number 6 is a letter dated 17th July 2025, conveying the Cabinet Secretary's approval granted on 15th July 2025 for exemption from import declaration fee and railway development levy, together with the conditions attached to the exemption, annexer number 6. The letter was from the PS National Treasury, but the approval was granted by the Cabinet Secretary on the 15th of July. Number 7 is a letter dated 3rd March 2026 on the importation of 27,839 metric tons of sugar by Mombasa Sugar Refinery Limited and the establishment of a multi-agency team, together with the minutes of the interagency meeting held on the 23rd of February 2026, which is annexure number 7. Then the assessment supporting the public interest decision is reflected in the application by Mombasa Sugar Refinery Limited, the recommendations of the Ministry of Agriculture and Livestock Development and the Ministry of Investments, Trade and Industry, and the approval record contained in annexes number 1 to 6. The assessment considered the identifiable fiscal cost against the anticipated public interest benefits of facilitating domestic manufacture of industrial sugar. Finally, Mr. Chairman, you had requested me to also address any other information or bring out any other information on the matter under discussion that the Cabinet Secretary may wish to share with the committee. It is important to distinguish the decision to grant the fiscal incentive from the subsequent administration and utilization of the imported consignment, Mr. Chairman. The decision should be assessed against the information, recommendations, and public interest considerations available at the time it was made. Number 2, the approval was intended to facilitate local refining of raw sugar into industrial sugar and was granted subject to compliance with the prescribed end use. Any subsequent failure to comply with the conditions of importation would constitute a separate compliance matter requiring action under the applicable customs and tax laws. And finally, where monitoring or investigations establish that the consignment was diverted or used for a purpose rather than or other than that approved, the relevant taxes, penalties, interest, and other enforcement measures will apply. Government remains committed to ensuring that fiscal incentives are used strictly for their intended purpose and that any identified weaknesses in the administration are addressed. I thank you, Mr. Chairman.
Thank you, Waziri. Thank you very much for very elaborate presentation to us. Allow me now to invite members who would want to seek for any clarification or if they have any question to you. We shall take 2 first. We shall take Honorable Kaitani and Honorable Undo so that we get answers quickly. Then we shall follow by Honorable Kishimo and Parashina in the next round. Then we shall go Honorable Kamene and myself.
Thank you, Chair. I'd like to first thank the CS for honoring our summons, or our requests, or not our summons, our requests to come and shed more light. And your paragraph 49 to 51 are very encouraging, if I may say so, especially in regards to this particular investigation. And relating to that, for us to be able to know that this sugar is not being diverted, so that this enforcement you're talking about is considered, what measures have you put in place so that you are able to monitor right from the time the sugar was imported to when it is converted to industrial sugar as it is meant or supposed to be and sold to only those people that are allowed to buy the sugar as industrial sugar. Number 2, Chair, paragraph number 7, you have said the relocation of the refinery from Kisumu to Mombasa and changing of the name from Kisumu Kibos Sugar to Mombasa Sugar. Are you certain that there was a relocation? And if there was, where would Mombasa Sugar Refinery then be? Number 3 is paragraph 8, Chair, where he has talked about this sugar being imported raw to be refined into industrial use. So if there was, and the only exemptions that were going to be complied with or applying there was import declaration fee and railway development fee. The presentation by KRA shows that the total taxes forfeited by this particular importation is not only for import declaration fee and railway development fee, it also has import duty, excise duty, value-added tax, sugar development levy, merchant shipping levy, total of which, can I continue? Total of which is 2.9 billion, 2,983,118 million. That is total taxes forfeited as we speak today. Your paragraph only talks about 2 specific levies. Paragraph 10, CS, you talk about the laws that allowed you to grant this particular import declaration levy fee and railway development levy fee waiver. And you've quoted paragraph XXV1 of Part A and Part B and X of Part B of the Miscellaneous Levies Act, which Levies Act I have read, and it actually talks about that you can grant, as a Cabinet Secretary, you have the powers under what you call public interest. I would like to know from you, CS, what is public interest? How do you justify what is public interest to allow you to do the granting so that the public understands what is public interest? And I relate that public interest to this country is a manufacturer of sugar. We farmers grow sugarcane, and therefore is importation of raw sugar, which could have been manufactured, public interest. Then paragraph, I will jump because the others I can come back later. But I will jump all the way to a paragraph where you have stated a letter that you did, dated 15th of July, 2025. They said a letter, P.S. Kipto wrote a letter making reference to a letter you wrote, or the Cabinet Secretary for National Treasury wrote, of 15th July 2025, but we have not had sight of that particular letter of 15th July 2025. Is it possible, because I have also looked at the annexures provided here, and that letter is still missing. Is it possible that that letter is provided? And finally, CS, in the meeting you had, which minutes are provided of the 23rd of February 2026 on this particular importation, you have made reference to approvals from the State Department or Ministry of Trade, Industry, and Cooperatives, and you've made reference to letters from the Ministry of Agriculture allowing that this process can continue if we can be able to provide those 2 letters that are made reference to. But in those minutes, the PS for industry confirms 30,000 metric tons of sugar coming from Brazil. And in that meeting, issues around KEBS and KRA as to whether this sugar can be allowed to come into the country with those taxes waived came up. the final sugar that comes to the market, now today we speak, is from South Africa. So when did the sugar for Brazil come? If at all it came, because there were tests done on it. And when did the South African sugar come, and when was the South African sugar approved, which is different from the Brazil sugar? Thank you.
Honorable Undo. Chair, in the various paragraphs, the CS has said that he made the decision based on public interest. I want just to, the CS, to probably explain to the country what really means, he intends to refer as public interest. Because public interest in typical dictionary explanation, definition, refers to the welfare, well-being, and common good of society as a whole. Article 10(2) of the Constitution says the only barometer, the only people who can determine public interest is through a process of public participation. I want the CS to give, to table in this committee, any evidence of public participation that was undertaken that determined that the matter going to a private entity could constitute public interest. Because public is public, can never be a benefit to one private entity. In paragraph 24, CS, of your presentation, you clearly says that the legal framework governing import declaration fee and railway development levy also permits the cabinet secretary to exempt goods where the exemption is in public interest or is intended to promote an investment whose value is not less than 5 billion. Whose value is not less than 5 billion. CS, when you go to your Annex 1, the letter from Mombasa Sugar Refinery Limited requesting for the exemption clearly reads as follows. The second paragraph, it reads as follows. Mombasa Sugar Refinery Limited, formerly Kibos Sugar Refinery Limited, commenced its operation in 2014, involving a significant investment of 20 million US dollar, currently an estimated 3 billion of Kenyan shillings. You have clearly said 5 billion. Here you have an investment that is merely 3 billion and is getting tax remission or exemption that is costing Kenyans close to 3 billion. How can that be in public interest? How can that be for good for this country? So it means in your own admission, you flouted the law by granting remission to a company whose investment was less than 5 billion as per the existing legal framework, which you have yourself have indicated. For now, finally, two issues. Number one, you say they will create direct employment, direct and indirect employment opportunities under your paragraph 16. It will be good to know, and you clearly says progressively, it will be good for you to tell the Kenyans what was the work plan, when were those intended jobs going to be created, after how long. Finally, for now, CS, is it common for you as a cabinet secretary, and probably also demonstrate, to convene a meeting to arbitrate a dispute between an importer and Kenya Revenue Authority? Is it common? Is it a practice? And since we, ODM, donated the experts to the current regime, how many of those instances have you had an opportunity to chair a meeting that basically resolves issues between an employer and Kenya Revenue Authority? Or was this a peculiar, a special case that required your personal intervention? We would be interested to know as people of Kenya. Thank you for now.
CS, I think you'll proceed.
Thank you.
And as you answer that, in case there is no tax remission, what will be the rate of duty for raw sugar imported from Brazil? And that one that is imported from South Africa. That is brief and specific. Proceed.
Thank you. Let me respond to issues that were raised by Honorable Keitani. She wanted to know that how we would ensure that sugar is not diverted, the raw sugar would not be diverted into the local market and not used for the intended purpose. First of all, by the way, let me clarify something that probably this committee needs to know, that we provide exemptions on a number of items, number of things, number of products in this country. It's not unique to sugar. Even steel for different use, for aid-funded or development-funded projects, and many other things. And it is the duty of the line ministry. The request comes from the line ministry. And it is the duty of the line ministry to ensure that the list, the master list that is provided, that those items that are imported, those items where we have either duty remission or exemption, are used or put to intended use. That is number one. But on this specific case, the reason why I even went a step further to convene and have an interagency team to monitor and ensure that the sugar that was imported was actually used for industrial use. There was a dispute. Kenya Revenue Authority had assessed this sugar and said that it is not raw sugar. KEBS, which is having the sole mandate of ensuring quality of products in this country, said it is raw sugar. Kenya Sugar Board said it is raw sugar. So there was that dispute. Now, when I convened the meeting, the first question that I asked was, if this sugar was put on the table today, can it be consumed? I remember asking that question as the chairman of the meeting. I was told by everyone that no. Therefore, I asked, is it industrial sugar or not? And they said, we agreed there that it was industrial sugar. KRA had issues with the coloring and all that. So we agreed there, and it was minuted, and everyone signed the minutes. Those who were present, the list is there. KRA, all these institutions, including the PSS, they signed the minutes and agreed that we form an interagency. That was my idea, that we form an interagency team to monitor that this sugar is not diverted into the local market, because then my concern went beyond my duty, my responsibility in terms of the fiscal, to even the human health, the Kenyan public health. Because if sugar that is brought into the country would be used for industrial use, would be diverted for human consumption, it would be unethical and it would be harmful to life. So I said that even though that is not part of my mandate, but I have a responsibility, and formed a team that was going to ensure that this sugar is only used for industrial use, led by the Kenya Sugar Board, because that is their responsibility. The responsibility of complying to make sure that sugar is not diverted into the market is the responsibility of the Kenya Sugar Board. And that is what we did. And we agreed that they will provide a report to me as the chairman of the committee, two interim reports and final report. They have done one. I'm waiting for the second. I am told that out of the mere 28,000 metric tons, about 6,000 has been put to further refining. So that is the response that I would give in terms of how we were going to ensure that this sugar is not diverted into the market.
Order CS.
Yes.
Is it not true that it is your responsibility to make sure that if goods are leaving to be as raw material to be manufactured or refined into sugar, you have to do it under the law, which is under you, maybe under customs warehouse, custom bonded warehouse, or under special economic zone, so that you are sure that the taxes that you have given or that are being suspended are actually taken care of?
Mr. Chairman, if you look at my letter, it's very clear what I said and what that within Kenya Revenue Authority had a responsibility. But beyond that, we formed an interagency team as a matter of precaution, including even security organs, because this was not it was not an ordinary matter. This was a unique matter, where we had a dispute between an industrialist who was feeling that he's being harassed. Actually, the report that came from the State Department for Industry was that we were harassing an industrialist.
Yes, I'm just asking, in customs, if you have to secure Kenya from losing taxes, you either manufacture under bond, you either manufacture under special economic zone. What prevents you? Because Mombasa sugar refinery in Kibos is not under any of that arrangement, which means sugar can move out and in at any time.
Mr. Chairman, the sugar for industrial use, the law would allow, and I would come to that we allowed the importation, we exempted the 2 levies under public interest, which is provided in law. All right? But we went a step further to ensure that this sugar is not diverted into the market.
Allow me, Chair. I asked that question specifically because we have visited Kibos. And the situation and the scenario, and we have also interacted with KRE. The situation and the scenario that has been presented does not have any control whatsoever. In fact, where the sugar is being manufactured and where the normal sugar is being manufactured is separated by a gate that is not protected, not controlled, not done anything. And that is why I ask, because you gave the permission or the authority, and in your letter and your paragraphs, you have said that the authority was solely only for production to industrial. If there is diversion, all the taxes should be collected. So in this case, what did you do to ensure that that is the case, so that the Kenyan public, because we're talking about 2.9 billion in terms of taxes, so the Kenyan public does not lose 2.9 billion?
You know, Chair, this to me is a very straightforward answer. We have 2 institutions that has the responsibility to ensure that what we agreed on was complied with. If those 2 institutions fail, then I know they have failed. It's the Kenya Sugar Board and the Kenya Revenue Authority. They are supposed to ensure that this sugar is only for industrial use. And we are very clear. You look at the minutes, it's very clear. If they didn't have the capacity, they would have told me in the meeting that they have no capacity. But they assured the committee that they have the capacity. And I still believe up to now that they have the capacity. The report I have is not portraying what the honorable member is saying. The report I have is that they have the capacity and they are ensuring that this sugar is put to industrial use. Actually, as a matter of fact, I will tell you that the confirmation I got from the same institution is that 6,000, close to 6,000 metric tons has been processed. Still leaving, out of the 28,000, still leaving about 22,000 intact, not processed. So these institutions have the capacity. And in terms of relocation of the company to Mombasa.
Point of order,
Allow me, Chair. So if 6,000 have been processed, is it possible that we get that report that has been sent to you so that we see how those that matrix is used, and more importantly, that 6,000 that is converted, who has it been sold to? If it's possible to know who it has been sold to, because we know selling refined sugar is not to the public. There are specific industries only that can buy refined sugar. So is it possible also to tell us that actually the 6,000 has been converted to refined and sold to these specific people?
Mr. Chairman, Mr. Chairman, the interim report can be provided, the first interim report. I don't know whether it was attached, but it can be provided. The issue of the 6,000 metric tons probably is not in the report, because I asked that verbally when I was coming to appear, just to get to know how much has been processed. But you see, Mr. Chairman, we have put the responsibility of ensuring compliance on the Kenya Sugar Board and KRA. If Kenya Sugar Board fails to ensure compliance, then we know they have failed. But I don't think National Treasury CS would go and follow sugar process sold to people who are making beverages, making pharmaceuticals. That is outside my province. I provided direction here because there was a dispute. And this dispute was interministerial. The State Department for Industry was very unhappy. Agriculture, Kenya Sugar Board, that we are discouraging investment by having tax collector. Actually, I came to this matter because of tax issue. The tax collector, and one of us asked, I think Honorable Undo, whether it is normal. I want to say it is normal, very normal, for me to intervene. You see, Kenya Revenue Authority is a tax collector. Tax policy is with me. It's not with Kenya Revenue Authority. That is the law. It is with the CS National Treasury. And every day I intervene where there is a conflict or misunderstanding between the tax collector and on policy matters. And this was clearly a policy issue, whether this was an industrial sugar or it is sugar that was that was processed already. So when this matter came to me on tax issue, I just went a step further because I got curious that in the event that this sugar would not be put to industrial use, it is not just about the penalties. Penalties is okay. We can reclaim, get the IDF or RDL. But what of human life? That is where it concerned me. That is why I formed the multi-agency task force, the team, to monitor and ensure and report back to me. And they have done one interim report, whether the sugar is put to industrial use. So I just went a step further. Actually, it is not really my responsibility. It is the Kenya Sugar Board to ensure that this sugar is put to proper use. So on the issue of certainty of relocation, the letters I got is that this factory has been relocated from Kibos to Mombasa, and it has changed the name. And the letters are there from the State Departments. So as to whether that was done legally, procedurally, those who are registering companies have the answers. On paragraph 8, IDF and RDF, let me just check what it was. Yeah, the law actually allow. If you look at my letter, I actually just mentioned that we allowed in my letter IDF and RDL, because that is what the law allows the cabinet secretary to exempt. VAT, I am not having any powers to allow that. I can only abandon tax, by the way. But that must also be justified after the tax falls due. But in this case, there was no tax abandonment. I don't know where the figure of 2.9 billion is coming from, which I think is incorrect. And by the way, import duty is provided under East African Community Gazette. It is standard. The duty remission is provided. It's a regional thing. It's not a favor that we are giving this company. Excise duty is exempted under the Excise Duty Act, and that is under schedule through the Tax Laws Amendment of 2024. We have that first schedule exempting, providing excise duty exemption. So it is only IDF and RDL which I granted. And just to tie it, maybe before I come to public interest, the letter that Chris Kipto, the principal secretary, wrote on 17th July 2025, speaking to a letter, speaking to approval from the CS, the cabinet secretary, I did not write any letter to the PS. The way we operate at the Treasury is if there are decisions which can be communicated by Principal Secretary, but have to come to me for approval, and it comes in a form of a file. So if you go back to the file, you will find my approval. I will have indicated approved, and I put the date, which is the 15th July. Once I approve, the PS takes that file with my approval and writes a letter now to the outside, to the third party, informing them that the Cabinet Secretary has already approved this under these conditions. So since I've not denied that I give the approval, the letter from the Principal Secretary is a letter from the National Treasury, writing on my behalf, approving the exemptions of Railway Development Levy and Import Declaration Fee, IDF. So there is no letter. I am sure there is no letter, but there is approval in the file to the Principal Secretary to communicate. So you asked a letter approving the release, that it was approval in the file. Now, on the issue of public participation, paragraph 24, and I want to go to that paragraph. I want to just take Honorable Undo to that paragraph. And he said they donated an expert. I still believe, Honorable Undo, I'm a serious expert, unless you have some doubts. But just listen to what I have written. The legal framework governing import declaration fee and railway development levy also permits the Cabinet Secretary to exempt goods and any good where the exemption is in the public interest or is intended to promote an investment whose value is not less than 5 billion. They are not mutually exclusive. It is either or. So I didn't have to look into the value of investment. I know it's 2 million US dollars. The 5 billion is not the legal framework under which I approved the Railway Development Levy and IDF. I approved it under public interest. And I stopped there. Or I just put or here because it is the law. So you read it in full. But it is either or. It is not public interest and. If it was and, then you'd accuse me of violating any law. But this is or. So the only question I need to address, how did I ascertain or convince myself that this is public interest? I think that is now where I would go to. Mr. Chairman, we have talked in this country and complained a lot about how we are inhibiting and interfering with job creation, that we are interfering with investment with unnecessary taxes. Now, when the law provides opportunity to promote investments by exempting taxes or levies to support job creation, then we want to ask ourselves, why was it done? And the question I ask myself, why did Parliament say public interest? And I have heard, Honorable Undo, you have said that public interest would have involved public participation. There is nothing that was difficult for Parliament to add that public interest after public participation. I don't think CS National Treasury would be at the National Treasury and conduct public participation on everything that comes to the National Treasury. I would not even do anything. I would be in the field all the time. Public interest is governed by many things. And here, the State Department responsible requested for this. And the letters are there. Agriculture said the same. State Department for Investment said the same. Now, my duty was to ask, and creation of direct and indirect employment opportunities. We were told that this company has created over 700.
Chair, since it was my
order, CS, let's have Honorable Undo. He was the one who asked the question.
Chair, I think the Cabinet Secretary is just being evasive and trying to evade to answer the question. The question is simple and straightforward. Article 10 of the Constitution is couched in such a way that the determination of public interest must by nature involve some form of public participation. We cannot run away from it. And public interest, even when you even I mean, look, the typical definitions is for the whole society. The question we are asking, Bana CS, in what way did you determine that a private entity constitutes a whole society? That's basic.
So let's have, on that one, we shall take only two more. Honorable Kaitani and Honorable Kishimo.
Thank you, Chair. The CS has made reference to two particular letters from the Ministry of Agriculture and Ministry of Trade. And as I mentioned earlier, those letters are not with us unless you specifically tell us so that we are able to see what is this public interest. And the other, just to buttress the point that Honorable Aunda has raised, what is, in the view of the minister, become public interest? What is it? Because you must have parameters. As if you say that it's not public participation, then what parameters would you have to grant you the knowledge to say, I am going to give this out of public interest?
Shimo?
Maybe, Chair, without belaboring the point, I just wanted to confirm if you look at paragraph 12, the decision was taken into account after considering the recommendations by the Ministry of Agriculture, Livestock Development, and Ministry of Investment, Trade and Industry. So I've not seen any letter in their annexures from the Ministry of Investment, Trade and Industry giving those recommendations. Even from the Ministry of Agriculture, I've not seen recommendations because under the provisions whereby the CS is supposed to grant that exemption, he is supposed to determine. For you to make a determination, there have to be some submissions. Yeah? Where you determine where it is in public interest. So that determination must have been based on something. And the CS has said there were recommendations. Let us have those recommendations which made you determine.
Yeah. Let him respond. No, I ruled out already. I ruled out, we must make progress. I ruled out already that we shall take those three because it's just a follow-up question. Let's not make it...
Chair, I don't know why members are saying they don't have these letters, but there is an next number 2, a letter from Principal Secretary Rono, a request by Kibos Refinery to import raw sugar from the world market for refining. And the letter reads, I don't want to go into details, the second page, in conclusion and noting the role of the government is to facilitate, maybe I started a bit, reference is made to the letter by Kibos Sugar, dated 11 January 2024, addressed to the Principal Secretaries for the National Treasury and the State Department for Agriculture, and then Industry and the ESC, and copied to the Commissioner General KRA, Sugar Directorate, generally in the opinion of the multi-agency team. So let me go to the second phase. In conclusion, and noting the role of the government is to facilitate manufacturing under the economic pillar of the bottom-up economic transformation agenda. It is recommended that KSRL, that is Kibos Sugar Limited, be allowed to import duty-free raw sugar from the world market to be used for processing into refined sugar for use in the manufacture of products for use in the domestic market. That such importation be in full compliance to the sugar import, export, and byproduct regulations, that the government embarks on high-level lobbying of the East Africa partner states to pave way for the amendment of the requirement that raw sugar be wholly originating for the products made from refined sugar processed by Kibos Sugar to enjoy market access in the East African community. And that is why we went to the East African community to lobby and get this covered under duty remission. There is also another letter from, from the Ministry of Investments, from State Department. This one, I think I have it. Yes. Yeah. So there is a letter from Muhwana, Juma Muhwana, to Chris Kipto. It's number 4. Importation of raw sugar, making industrial sugar in Kenya. This matter has been discussed with an interministerial team chaired by the head of public service, Honorable Felix Koskei, that brought together the State Department for Industry and other State Department, National Treasury, and everybody else. This is to request that you initiate within the Kenyan Duty Remission Committee a discussion to initiate an East African community-level regional-wide duty remission scheme. And then there will be also need to put in place an interagency mechanism that will monitor and ensure that all imported raw sugar is not diverted into the local market, but used solely for making industrial sugar. The purpose of this letter is therefore to request you to convene the meeting of the Duty Remission Committee to facilitate discussions on this matter. And that is what we did. But, Chairman, let me also point out that even without letters from the State Departments, these are just enforcing and emboldening my decision. The Cabinet Secretary is not under any obligation to wait for letters to come from State Departments if I'm called upon to approve exemption of taxes. It is a responsibility I have, so long as it is within the law. I am being asked now to prove public participation, public interest, that it must be only public participation. I'm yet to see that Article 10. I've read the Constitution, where it says public interest is equal to public participation. You elect people in office who have public interest. That is why when you are taking your oath of office, you commit yourself that you will take decision in the interest of public. We do public participation to pass laws. Once we have passed the laws, we cannot be referring to the public every day we are making decisions at the Treasury. I would be lying. How do you expect me for every file I want to sign at the National Treasury, I have to go to Kisumu, I have to go to Mombasa, I have to go to Garissa to conduct public participation, whether they agree? And I'm being asked whether allowing an importer. Let us not look at this as a private business. This is an investor in this country. Unless we have a reason why we have a problem with him. He has invested his money here. He's creating employment opportunities. That kind of attitude is what is making us not create enough job opportunities in this country, Mr. Chairman. And I'm surprised that it's coming from my friend, Owundo. You cannot refer to an investor as a private business. Investment should be done by private people, not government. I've said many times that government is not in the business of doing business. How do we attract investment when we refer to their investments as private business?
Yes. Chair, now the CS we have a point of order. Mentioned me. A private entity is a private entity. A public entity is clearly defined in the Constitution of Kenya. A private company owned wholly by private individuals is not a public entity, so cannot qualify to benefit from any public interest or public goods. Yeah. This is obviously an abuse of the powers granted the human. That's what is your question. So the point is, we are yet to see the purpose, any demonstration of public interest. If you are telling us jobs have been created, where are the jobs? If you are telling us since the raw sugar was imported, was it last year? We are now 12 months down the line. Where are the jobs? Where are the direct benefits to the people of Kenya to justify public interest? Chair.
Yes. Is it on the same?
Because on the same thing, Chair. Yeah. Kindly. On the same thing, Chair.
Yeah.
Chair,
1 minute.
I just want to
direct.
Even a single 30 seconds is enough, Chair. But let it go to record, Chair. And I wanted to address the Cabinet Secretary through you, Chair. Basically, what the minister is doing is relying on the policy. And not to try to fight that and say, all of us understand the policy. But there is an inquiry concerning this specific case on the importation of the raw sugar. And what, when you say, even the 2 letters that you submitted, Waziri, if we are not able to establish, because we say Roman 1 to Roman 8, creation of direct and indirect employment, transfer of knowledge, particularly there's not a particular technology that has been transferred. If you say number of employment opportunity, we could have been able to see a exact number of people who have been employed and who are benefiting from that employment. The other thing you said, local manufacturer benefiting from the importation. Kibos is only one person benefiting. Where is the other chain of other people benefiting? Because the issue of this sugar is that we are, and I will ask later in my question, but let not be asked now. We want to have chair, specific issue, not policy write-ups. Want specific items. Say A is A, say number one is number one.
Proceed, conclude that.
Chairman, you know,
just conclude that particular.
You know, in terms of the jobs created, if you are doubting the 700 jobs, it's easy to confirm if the 700 people are not working in that factory. If you are disputing the chain, it is not just Kibos which is benefiting. My understanding is this sugar is being produced for industrial use. Pharmaceutical companies. There are so many people in the value chain who will be benefiting. Those who are manufacturing pharmaceuticals, those who are doing the food, beverages, they use this. And by the way, Honorable MP from Kajiado South has asked me, through you, Chairman.
And just address the chair.
Yeah, please. Through you, Chairman. He has asked me that which is the skill being transferred. The fact that we have no factory in this country up to the establishment of this one, manufacturing refined sugar, is clear evidence that we need skills transfer, technology transfer. And so I expect going forward that more players will come into play to also establish refining of raw sugar into finished products. So really, what is the question here? Is the question that it is wrong to allow industrialists who is establishing a factory to refine raw sugar into finished product to substitute finished products that we have been importing in this country? Is that what we are saying is wrong? Or what is it? I need to
whatever
understand.
is wrong, Chair,
I need to understand.
CS, what is wrong is the procedure. In principle, we are good, but the procedure you have followed. We are asking you specific questions which you are not answering properly because KRA is under you. And in KRA, securing taxes, it's only under bond or a specific arrangement which is under the law. Under this, you are saying is up to a report that will come after you, will come after they have cleared the goods. It's not wrong. We are encouraging investment, but we want it to be operated under the law.
Mr. Chairman, we followed the law. Let me tell you, the law is clear. It gives the Cabinet Secretary the responsibility to exempt RDL and IDF in public interest. And I have ascertained myself that there was public interest in this. This is a factory that has been established to create employment. This is a factory that is substituting importation of finished product so that instead of buying finished products to put in our beverages and to put in pharmaceutical products, we bring raw materials and process them here. That is what this government is for. We want to manufacture here. The time you are manufacturing, you are employing more people to manufacture the raw sugar into finished product. To me, that is public interest. There is nowhere in that law that I've read where it says before the CS ascertains public interest that he has to do public participation. I have not seen it. And Chairman, that is insofar as tax exemption or duty exemption goes. In terms of ensuring compliance, I have said here categorically, Kenya Sugar Board has a responsibility to ensure compliance, and KRA, and they have not abdicated that responsibility as far as I'm concerned. I just went a step further to create multi-agency team to make sure that no gaps are left, including security sector. If that is bad, I take responsibility to doing extra. I went a step further to do extra. It was not really my responsibility. Once I give tax exemption, it is not my duty to go and check. Chairman, I give tax exemption on imported steel, raw materials used even for road construction. I don't go to the roads to confirm whether they have been, the materials have been used on the roads. There are people who do that. But on this one, and I said it before, on this one, I decided to exercise more caution because I felt if there is, in the event that this sugar is diverted into the market and not used for production or further processing, it would endanger human life. So I don't know what is being said that I've not responded to. I have responded to everything.
Respond for on further. We can't. We shall make our decision if the CS has answered adequately or not, because we can't remain on one particular question forever. He still has more questions to answer.
And Chair,
let him proceed. Yes. Answer the other questions.
I think I answered all the questions.
You have answered all.
No, Chair. Okay. There was the question about Brazil sugar and South Africa sugar.
I don't think that is what I was looking at. That is for the State Department to deal with, whether sugar came from South Africa, Brazil, or wherever. The law only allows us to...
Chair.
Order.
Chair.
Let's have one person.
Chair, I made reference to a meeting that the CS chaired. And in that meeting that the CS chaired, which minutes he has provided, I think page 3 of 11 of those minutes talk about the sugar being 30,000 metric tons coming from Brazil, expressly waiving the consignment on 2 parameters, color and polarization. That is a meeting that the CS chaired. And this was submissions by Mombasa Refinery. And finally, in the submissions that were done by the various state agencies, KEBS and KRA included, and where the bone of contention came from was on that particular sugar of Brazil, which was that the sugar of Brazil that had been brought for tests, KRA did not agree with what was provided as being raw sugar, and said they are going to charge normal taxes. And KEBS and SGS gave different opinions as to what that sugar was, whether it was raw or not raw sugar. But that was sugar from Brazil, and that is the meeting you attended. But the sugar currently imported is not sugar from Brazil. It is sugar from South Africa. So I was asking the question about the sugar from Brazil and the sugar from South Africa. If you cleared the sugar from Brazil, how about the sugar from South Africa?
You know, Chair, regarding where the sugar was coming from, for me, it is very simple. It didn't matter where the sugar was going to be imported from, but it was mentioned it was Brazil. It was the duty of KEBS, Kenya Sugar Board, to determine all these other parameters. That is why they took the responsibility to monitor and follow where the sugar had come from, how it has landed, how it was going to be used. So it was not really my duty to know what interest would I have had.
Sugar did you approve? CS. Is it the one which came from South Africa or the one which came from Brazil? It's a direct question.
You see, Chairman, I think we are not communicating. I approved importation of raw sugar, the exemption of duty on raw sugar, regardless of the origin. It is not my duty to find out where they bring the sugar from. What was required was for me to give duty exemption on RDL and IDF on sugar that landed at the port. Whether it came from Korea, it was not my business. It was not my duty, unless there was a reason to ask the origin of that sugar. But in the meeting, there was a mention that the sugar was from Brazil, and there was a mention of the color. And we discussed the issue of the color in that meeting. And we came to a conclusion that this sugar was raw sugar. And KEBS confirmed. KEBS confirms and satisfies qualities. Kenya Sugar Board was agreed with them. So what else could I have done as CS National Treasury? To go and do the test myself?
Chair, allow me not to belabor on this matter, but just to state something, and I would like this to come on record, that the sugar being talked about, whether color or what, was a specific type of sugar that was being talked about. The color of the sugar and the polarization of that sugar was a sugar that was coming from Brazil. And that was the sugar that both KEBS, KRA, and all entities who sat in that meeting made reference to. So, and that is the reason why we are saying, you can approve any other sugar, but the sugar that had the changes and the issues that we're dealing with here was sugar specific, tested from Brazil. But the documentations that have been attached show that this sugar is from South Africa. So meaning the sugar from Brazil had these approvals. What about the sugar from South Africa?
I think, Chair, that is not correct. I think we need to, if you call the relevant ministries here, they will tell you. I think, if I recollect very well, there was the approval to get sugar from Brazil, but they got it from elsewhere. And there was no reason, there was no problem with that, if you ask me. Whether it, so long as the sugar that came was raw sugar, and so long as we could monitor that sugar up to the factory and outside the factory, to me that was the most important thing. And we had put a multi-agency team to deal with that. If this multi-agency team fails us, then we know we have the wrong people there. But it was not for me to go and check whether this is Brazil or South African sugar. That is outside my mandate.
Yes, Kishimo. And I asked a specific question on import duty on sugar from Brazil and import duty on sugar from South Africa, which you have not answered. But you'll answer that because it's specific. You'll answer as you answer Kishimo's question. It's a follow-up question.
Maybe you again paraphrase it, Chairman. I don't think we picked it.
What I asked is, or let me repeat, if you import sugar from Brazil, raw sugar from Brazil, what would be the rate of import duty? Then if you imported from South Africa, what would be the rate of import duty? Response.
Chair, import of sugar would have cost 100% import duty, or $460 per metric ton, if there was no duty remission. On this one, we secured the duty remission in the East African community, and therefore at 10%.
Why I'm asking, I asked from two different countries of origin. If it came from Brazil, what will be the duty? And from South Africa, what would be the duty?
I think there's no duty difference, Chair, because South Africa and Brazil are outside the East African community and the COMESA. Is South Africa part of COMESA? I don't think so. The price would ordinarily, the duty would ordinarily be the same for the two origins.
All answer I was looking for. Let's proceed. Now we take another round. Yeah. So I want us to be brief so that we can cover other members who are waiting. So we start from Kishimo, Parashina, Kishimo, then.
You had already given me the mic.
Okay, proceed.
So before I lose my my points or line of thought, CS, I really appreciate you for taking the initiative of bringing all the maths for there to be like some coordination in terms of dealing with this raw sugar. And I believe the reason would be because you are faced with an unprecedented issue of importation of raw sugar. And where, in my own research, there existed no regulations on how to deal with the raw sugar. other sugars, you've never had these kind of things because there are regulations governing. Maybe out of that meeting, did you ensure, as the person who brought all this MAT, that now regulations were put in place to guide the process of importation, transportation, processing, and anything in respect of the raw sugar? And the first question you asked us, as per your statement, is that can they, if this sugar is placed on the table, can it be consumed? And the answer you got was no. I think the right question would have been, would this sugar be good for human consumption? Because if you just place it there and someone consumes, maybe someone can consume, but is it good or safe for human consumption? I think that ought to be the right, but let me go to the other question so that I don't take too long. If you look at your annexures 2, form part of the letters that the ministry considered prior to granting of this exemption. The first letter, there's one letter dated 11th of January 2024 by Kibos Sugar Refinery Limited, which was applying for importation of duty-free raw sugar for manufacture of industrial sugar, which was followed by a letter dated there's a letter dated 6th February 2024 by the Ministry, State Department for Agriculture. If you look at those letters, I believe there is a disparity in terms of documentation because those letters refer, including the one that applied for importation by Kibo Sugar Refinery Limited dated 11th January 2024. And if those were the basis under which then you also considered that importation, then I think it's wrong, because the document that we have is that Kibo's Sugar Refinery Limited changed its name to Mombasa Sugar Refinery Limited on 14th November 2023. Yet, their letter is dated 11th January 2024. So it means that this application for importation of raw sugar was made by a wrong company or by an non-existent company. Maybe you may need to clarify that, because the document that I have on the change of the name is dated 14th November 2023, unless you have a different one. So maybe those are some of the areas that I would like clarification, Chair. I think the other issues have already been answered.
Parashina.
Thank you, Chair. And I don't want to take you back because you say that we go to prayer specific questions. But I start by as a maybe appreciating the coming of Waziri. You said thank you for coming to shed more light. And now you also say that you approve, you just approve whatever the request come on the sugar raw, on the importation of sugar raw, without really looking at nitty-gritty where it comes from. So that's another question that the committee has also been able to get it up. But now, since you form a multi-agency, you had to form a multi-agency to check, or even during the time of giving out the approval, for the sake of the country, kindly, this is my message, kindly, tell your multi-agency, those multi-agency people who are working there, for the safety of the country, the specific sugar, raw sugar, is under query kindly, so that we will not lose the Kenyans just to benefit few, or some people getting advantages of bringing certain items in this country, and they run with the money, and the Republic suffers more. And I want, Chair, because I know we used to come with one party, and they was used to my chair. I want to take you back to 2024. As though history repeats itself in this country. You as a cabinet secretary, you are responsible in terms of oversighting KRA. Is it also? I think that's the case. 2024, I just wrote here, there was a case on importation of contaminated sugar, where KRA again lost money. So Kenyans lost revenue. During that case, the Vinpac case, it was called a Vinpac case. And the sugar was coming from Mauritius. Now, a multi-agency was formed like this one. So I just want to say, tick. And in fact, in basic understanding, it is when you form a multi-agency, is a simple way to run away from responsibility, Chair. Because a case is supposed to be done by one person, then again now it's from 20 people. So that the person who takes responsibility it's not able to trace who takes the responsibility. So multi-agency that was from that time there was a lady in KRA who was even fired. A staff from KRA was fired. Those juniors suffered more, but the cabinet and those people who are within the apex are enjoyed. They move in big cars and live in big places. But Kenyans lost. Chair, I'm bringing a point here. That time, the sugar was contaminated because it had mercury, and they would say that that sugar should be destroyed or used for ethanol. To today, there's no single evidence of the mercury contaminated sugar with mercury that was destroyed or even used for ethanol. So, ukiumwa na nyoka, ukiona kamba, ogopa. This is the same scenario. So, Chair, that's one question I wanted to ask Waziri. You had also been a member of parliament. And there's a way people run away when member of parliament do inquiry. Since we are doing inquiry of this sugar, and it's our belief that this sugar is getting into the market, basically itakaushwa kidogo tu kwa sababu inaonekana kama mafuta ikaushwe, then it gets to the market. So, how are we going to get report? How are we as members of parliament of this committee be able to take you liable, or you can take a responsibility because you are also forming the multi-agency and the KRA fall under your purview, or it will be members of parliament are just making noise. Because if you are making noise, just let the public know that we will never get facts about that sugar. It will get to our lives, and those who die with the cancer will be our people. Finally, Mr. Chair, if you knew there is no regulation, there is a law, yes, as my senior said, but there is no regulation. If there is no regulation, how do you put it in practice to say that it is taking care of public interest, and there's no single regulation allowing you that? So what is this rush? In Mombasa, I saw those white guys there in Mombasa. When we go to Kisumu, where you come, because the sugar also come from there, even the place they said to accumulate that sugar, the space is too small. It just shows there's like a small place for ingie, we kausha the thing, iende Kedhorai. Na uzuri Mungu ni mzuri. Itaanza ni Kisumu and Siaya Chair. Kindly let us believe, because it will start there before it gets a Masai in some. No. Before it gets in Kajiado, it will start in your regions.
There is a store here. There is a store here.
Let's be brief. Honorable Wainaina, then we close with Kamene on that one, on your questions. Be brief to the questions.
Thank you, Chair. Mr. Wasiri, this factory of Kibos opened 2014. It has taken more than 12 years before it started working. And all that time, when you open the factory, before you invest in a factory, you must first of all do research where you are going to get your raw material to do that factory. And for that matter, I am sure they have looked and checked that this factory we are implementing, we are going to get raw material. From all that time, that factory was not operating. It operated during this about one year after started operating. Why was it not operating that 12 years? You told us that they said that there was harassment between those situations because they were not operating, they were not getting raw material. Basically, when we went there and we tried to investigate what is low sugar, low sugar is almost a table sugar. And when we try to ask those people, how can you differentiate this sugar and low sugar? What they told us, and those people who were there even kept, is just that wetness. Even if you do that sugar, you put it to the sun and get dry, you can take it to the table sugar. The other thing, what we were told, is only the particles, because when they were loading, they were just scooping to where it was done, scooping to the ship, and that particles is only different at table sugar and low sugar. By that, you were saying, when we say here, we are bringing low sugar, who is benefiting out of this low sugar? There before, we got information that when we are trying to save this manufacturer, we increased the duty for low sugar, which is being used by manufacturers. That means all those manufacturers, when they go to buy their low sugar to make their product, the low sugar to make their product, they will increase to their prices at 5%. If that's the case, Wasiri, there is many factories which in this country, and that factory will not be able to meet the demand of those factories. Those people, Wasiri, they will go and buy low sugar, they import sugar with an increased duty because of protect this factory. In that case, somebody have invested, Wasiri. He have opened a factory based by what it was there before. Then when you go to import sugar, he was told that you have to increase that 5%. But this factory itself, it is not meeting the demand of the country. Uganda, they have factory of low sugar. For us to do increase of duty or excess duty, we have to meet the East African community. This we did currently, and Uganda, they have been manufacturing those sugar, low sugar. And I'm sure even this factory was intended, and when they were making this factory, they were looking to use the local sugar cane, which we used here. They were not intended to import that low sugar. Now, between us and the low sugar which is coming, where are we benefiting? Because there's a low sugar which is already finished. We are just coming here to do the final tune it, just cleaning and make it here the head of it. We are not benefiting. Ms. Wasiri, we are saying here we are employing people. It is true. We are creating job. We are creating job one factory. But you are killing job 10,000 factory. Because those people who are small factory will rely with that big factory. And that big factory, Wasiri, and I want to do here, this is not happening. I'm an expert of small industry. What happened is that those people will not import small quantity, they will rely with this one. And they will close their small business, rely with one person, employ 700 people, and they have employed 200,000 people. And that is my take.
Honorable Kamene, then he answers, then I'll come back to Mwalio and myself.
Chair, let me start from appreciating the CS for coming before us. But what I've had today is very amazing. Chair, we got an opportunity. Let me just remind every one of us, we got an opportunity to start from the port. And that the day we went there, I wish our people could give us those videos that we took. We did not see any multi-agents. We did not see any multi-agents people there. In fact, the only person that was there and was of use was the chair of the Sugar Board, Kenya Sugar Board. Next, we came to the depots here in Nairobi. The same was the case. What we saw there was another even total different from what you're talking about. In short, the multi-agency and the sugar board that you're hailing responsible for all this. I think the sugar board, even when we called them, I think there were only 3. And one is the one who was only appearing. And answering questions was also a problem. And it looked like everything has been organized from the treasury. Everything is from the treasury. It has proved now. Indeed, it's like everything is being organized. And even if it is being organized there, Waziri, you're so qualified to understand that there are procedures. The issue of the regulations. How do you just put everything, let's start in the market. What is this hurry about? Kibos was not going anywhere. This importation of raw sugar was not going anywhere. Why didn't we get good procedures so that we can protect our people? As we told you and we are insisting. It is there. It is being processed in tandem with the other white sugar. How are people? Why didn't we get a bonded warehouse? Yeah, why didn't we get a bonded for you to ensure that at least you want to protect the people of Kenya, to make sure they'll not use this contaminated sugar. But somehow everything has been rushed. Sure. Now this day is very wrong. You have to answer us. We want you to explain us. We want to understand very well why all this has been rushed that way. We have no, and why aren't there good procedures? Imagine, it is so sad.
Okay, let's Waziri answer. We can't take all.
Mine is so short.
Okay, then we close.
Yeah, thank you very much. Thank you, Waziri, that you are here to prosecute this case and be able to answer all those. From the word go, the sugar board people lied to you that that Kibos was right to import this raw sugar, because first of all, there were no regulations for raw sugar. Number 2, the board was not properly constituted. The board's quorum is 7, and there were only 3. So from the word go, everything went wrong, and they lied to you because you are up there and they are down there. They thought they knew you don't have those nitty-gritties. So they were not in the right standing to even give a permit because they were not constituted. No director was representing the farmers themselves. Even now, there is no one. So the whole thing is a saga because the importer had maybe spent so much money on the factory and then was in a hurry to bring that the consignment. That is why you had to fetch even the consignment from South Africa, from Brazil, so that the ship can be filled with all the consignments from different places to bring it up in a hurry. So the whole thing is a saga which should have been done in the proper way. Even now, if he finishes whatever we saw him processing, how will he bring another consignment for continuity in the market? Because the board is not even constituted. We'll go to the same saga.
Not responded to properly. Just allow me to reframe based on the letter written by the PS to the Commission agenda on 17th July 2025 on the issue of timelines. In the third paragraph, the letter, the raw sugar shall be imported in accordance with the South African Community Council Management Act 2005 regulations. If the raw sugar is not refined into sugar for industrial use, the applicable taxes include import declaration fee and development levy, and the penalties and interest thereof shall be due and payable to the commissioner. The question I asked, which was not answered, what were the time frame attached to the processing of the raw sugar for industrial use? Or was it open-ended? It could as well take 20 years or 50 years. Thank you.
Yes, Waziri, you may answer those ones. Waziri, the point which is not clear here, you did very well to make sure you have put multi-agency task force in place to make sure that goods from the port to Mombasa Sugar Refinery arrive in safe hands as per the thinking. But now, in your submission, number 35, you write that the approval purpose of the consignment was refining into food grade and pharmaceutical grade industrial sugar. Compliance was to be ensured through controls over the release, movement, custody, processing, and utilization of the imported raw sugar. The issue of custody here is a sole responsibility of KRA, which is under your ministry. So the question is, there's a legal framework on how to make sure goods remain under the custody of customs, whose taxes have not been collected fully until it is processed. Once it's processed, then we are safe. We know, okay, it is used for the intended purpose. That is the area I want you to come out clear, Waziri, and tell us the issue of custody. How have you made sure under the law that it is there? Because it's not the duty of multi-agency team. It's the duty of care.
Yeah. So, Chair, maybe I respond to that first. By the way, nothing that I approved waived any requirement in ensuring that the release of commodities is governed by the applicable procedures. KRA has standard procedures. In my communication, there's nowhere where I've asked any agency to waive any requirement for anything. And Chair, allow me to respond to Honorable Undo before I forget. There was a commitment that is in the minutes of 2 months to make sure.
Yes. You know, before you approve, even in your approval, you must have said what you're saying, that all other procedures must be followed. Did you say that?
I thought that was in the letter to the from the PS.
That is what we
all
want
the
to
time
follow.
we mention that all the applicable laws, they have no powers to waive any procedural requirement. They have no power. In fact, if there's anywhere where I said that there was supposed to be waiver of any requirement, it should be pointed to me. I have not waived anything.
Chair, because the CS has said approval is on a document that he gives to the PS, then the PS communicates that approval. The letter from the PS then that communicates the approval from the CS actually states reference is made to a letter from the Managing Director, Mombasa Sugar Refinery, dated 23rd June 2025, requesting for exemption of import declaration fee and railway development fee on raw sugar imported under duty remission and refining into sugar for industrial use and deferment of payment of value-added tax to the time of selling the sugar and after refining. After due consideration, the Cabinet Secretary, National Treasury and Economic Planning on 15th July approved exemption of import declaration fee and railway development fee on raw sugar imported by Mombasa Sugar Refinery under duty remission scheme to manufacture sugar for industrial use in accordance with paragraph XXV1 of Part A and paragraph X of Part B of the second schedule of the Miscellaneous Fees and Levies Act, respectively. The raw sugar shall be imported in accordance with the East African Community Customs Act 2004 and its regulations. If the raw sugar is not refined into sugar for industrial use, the applicable taxes, including import declaration fee and railway development fee, and the penalties and interest thereon shall be due and payable to the commissioner. Then, in respect to the request for deferment of payment of value-added tax, there is no provision under VAT Act to enable the Cabinet Secretary to approve deferment of payment of value-added tax from the time of importation of the raw sugar to the time of selling the sugar after refining. Therefore, VAT shall be payable on the raw sugar at the time of importation.
So, if you from that reading, clearly we said that the law must be complied with. There's nowhere where we waived any law. We said categorically through my PS that all the provisions governing importation must be followed. So that is what we did.
Allow me then, because I read the letter. You see, this letter then should have come out to say that for purposes of making sure that this sugar is properly followed, the procedure is properly followed, it shall be bonded until such time the process is complete. Because when you leave it open, because this is a letter attached by KRA, and if you look at what KRA said, they say they based their judgment on the letter you wrote, and that's the reason why they have not bonded that sugar.
You know, surely, Chair, once we have quoted the law, you want us to go to procedure, to tell the KRA procedure. That's not how we work. Honestly, that's not how we work. You see, when you are giving exemption, and I write these letters every day, I don't go spelling out to agencies that you will be producing the master list and giving it to us. It is the procedure. They will be doing the master list and submitting to the Treasury. So the question I thought, Chair, that you are seeking from the National Treasury is on the tax policy. Why did we exempt this manufacturer or industrialist from RDL and IDF? In fact, the issues that we are now talking about on the safety, security of sugar is not even in my province. I just went a step further because I convened this meeting. In fact, the reason why I convened the meeting was not about quality. I convened the meeting to discuss whether IDL and IDF, whether this manufacturer or industrialist qualified for IDF and RDL. And that is based on whether this was raw sugar or table sugar or finished sugar. And the discussion we had there was that this is raw sugar. Now, I went a step further because I just, out of caution, in fact, what the members are asking me here, in fact, one of us said that, thank God, it is from Kisumu. By the way, I have a cabinet secretary for the whole country, not for Kisumu, for the whole country. I would be equally concerned if my brothers and sisters in Kajiado South, their lives would be endangered. And no one knows who would have consumed this sugar. And we are national leaders. You are members of National Assembly. When I was representing Super South, Mr. Chairman, I was not just speaking for Super South. I spoke for the whole country because I was a member of National Assembly. That's why you are called member of National Assembly. You are not member of County Assembly. So the question of Homa Bay, Kisumu, Nini, Kajiado should not arise from national leaders, Mr. Chairman, with all due respect. But the point is, I was trying to make sure that we protect the lives of Kenyans by forming this multi-agency task force. It was not replacing other procedures that are established by law. The other procedures remain. KRA still has an obligation. They are the tax collectors, and to ensure that that whatever decision is taken does not compromise tax collection. So and let us not be emotional about this matter. This is a serious matter, and I have come here to address it because I know it is a national issue. I have not come here, Chairman, just to downplay the significance of this committee, and that is why I'm saying there is something that we noticed in my discussion, because one of us, and thank you, Honorable Gishugu, MP for Gishugu, you had a very, actually, not the, was it MP for Gishugu? Yes, it was the MP for Gishugu, he has left. out of the
committee-
engagement
the
I
question
had,
for the committee, yeah.
were there gaps that I saw? Yes, there was. One of the gaps was that this is KEBS, a national institution, a national agency, has a different position from KRA, from Sugar Board, Kenya Sugar Board. I said we must standardize our systems. In fact, one of the KRA guys said they don't use international standards. I remember in that meeting, and I said that is wrong. We are not operating in isolation. We are not an island. We must operationalize and standardize our system to conform to international standards of testing, quality of goods. And by the way, KEBS has a bigger responsibility. One of us asked whether I would be held responsible. I think it was Honorable Kamen. How do you hold me responsible? I am not responsible for quality. We have KEBS responsible for quality, and that is why I invited them. And none other than the managing director was present there. And she told us, this is raw sugar. And she can come and confirm or deny. And we took minutes, and they all signed. In fact, we made sure they signed on every page, including even blank pages. So, in terms of quality, it's supposed to be guaranteed by KEBS. Kenya Sugar Board should guarantee quality. Kenya Revenue Authority's responsibility is not even quality. Kenya Revenue Authority responsibility is to ensure on tax collection, period. Now, I need to check whether when Kibos changed to Mombasa Sugar, but I was clearly told that they changed the name, and therefore subsequent requests came, they relocated to Mombasa and therefore changed the name, and therefore that was it. By the way, in terms of discussion around whether we are...
CS, I think that was specific. If our secretariat can show you the two different documents.
Yeah.
Because he mentioned even the dates. The documents are on the file.
Which documents here, Chairman? Maybe I don't have that
the
document.
Application, the date of application by Mombasa Sugar Refinery and Kibos Sugars. By the date they applied as Mombasa Sugar Refinery, the company had not been formed. I think that's the point he was making.
That would be interesting, but I think maybe that is a question, Chairman, you could find out from A, the company itself, and 2, registration of company, and 3, the line State Department which made the recommendation, because I acted on the basis of the recommendation of...
He's back himself.
Chair, what he was
This
saying...
is your question.
Your question, yeah.
He was answering the one on change of dates. He wanted... Can you take it again so that we are on the same page?
No, I was just just looking at the disparity between when the application was applied or was made, the application for exemption or for importation and exemption by Kibos Sugar Refinery Limited, whereas the name had already been changed to Mombasa Sugar Refinery. So this application, in a nutshell, was made by a non-existent entity. And further, the recommendation by, although the CSA, he is not bowed by any recommendation by any other department, although that recommendation by the State Department for Agriculture also indicated they had no objection to Kibos Sugar and Allied Company Limited being given that or being approved for that, importation. So that was the issue that I was raising.
Waziri, proceed. I had interrupted you. Sorry. So proceed.
I may need to get to those dates that Honorable Member is referring to, where the name, from the way I understand him,
Through you, Chair, Annex 2, part of your documents, there is a letter by the State Department for Agriculture. Just after it, there's an application by Kibo Sugar Refinery Limited, dated Thursday, January 11, 2024.
But you are contending that they had changed the name on which date?
On 14th November 2023.
Was that change of name or application?
Sorry? To a certificate of change of name. Or what document?
No, I don't have that certificate. I don't have it.
What document do you have under paragraph 7 where you have indicated following the relocation of the refinery from Kisumu to Mombasa, Kibo's Refinery Limited changed its name to Mombasa? Oh, okay.
You see, what I was referring to is that subsequently, in 2025 now, 23rd of June, it was now not Kibo's that requested, but it was now Mombasa Sugar Refinery because they had changed the name. So that is what I referred to under that paragraph.
So are the annexures under Annex 2 relevant in this case? Or in your submissions, are they relevant? Because at that time, the applicant was Kibo Sugar Refinery Limited, which was non-existent.
Chair, what my response to that question would be that the relevant bodies can be asked at what point, because I don't have the certificate of the change of date. I am seeing it here for the first time. I'm not having that certificate. And I'm sure there are competent bodies to address how the change of name came about. But for me, what I reported here is that Mombasa Sugar Refinery subsequently applied on 23rd of June 2025 because the name had changed from Kibos to Mombasa. The contention from the member is that at the time we were approving for Kibos in 2024, Kibos had ceased to exist. Yes. Yeah, so that is a question that first can be addressed. You see, if you look at this, the letter from the principal secretary, which is dated 2024, yeah, this letter, the PS referred to Kibos, and it is 2024. But the contention is that the name had changed in 2023. So the people who can address this clearly is not me. It is the PS who referred to Kibos Sugar, and also the Kibos and any other person who is involved in the registration. For me, what I was reporting here is that Kibos transited to Mombasa, because that is the information I had. And it is only in 2025 that now Mombasa Sugar applied. The earlier ones, we dealt with Kibos. So that is what I wanted to clarify. Chair, there was a question.
Allow me, Chair, just on the same annexures. On that same annexures, annexure 2, the letter from the PS to PS Agriculture to PS National Treasury.
Which annexure is that?
2.
Yes.
2, the same annexures, where you have made reference that the PS made a letter by Kibos, which Kibos did not exist, right? So that's same annexure. And the PS, because PS for Agriculture wrote to PS National Treasury, your annexure 2, the first letter. And in that letter, because you said you based this letter on public interest, the PS in requesting for approval said that such importation will be in full compliance to the sugar import, export, and byproduct regulations. And we know the regulations do not exist. Up to today, don't exist. So if the regulations do not exist, what public interest were we using for what did not exist? Because he's making reference. So in short, he is actually trying to run away and give you the baby with the bathwater to hold.
I really don't see what that would be problematic about. No, I don't see. Because there is nowhere, in my view, which says that public interest can only be determined through regulation. Where is that?
What I mean is, a law, when we make law, the law becomes, especially where it says this shall be done by regulation, it becomes now active when the regulation is passed. You can make a law and say this law shall become active by regulation. So in this case, the regulation that existed did not allow raw sugar processing, importation or processing in this country. And the PS has made reference to that regulation, which does not allow raw sugar into this kind of processing of raw sugar, importation and processing of raw sugar into the country.
Paragraph are you referring to? Can
Paragraph,
you just take me there?
page 2 of that letter. In conclusion, and noting the role of government is to facilitate
Annexure 2.
manufacturing.
I don't have the letter from
No,
PS.
you do. It's the first letter.
Is it Annexure 2 or which one?
Annexure 2.
Okay.
It is Annexure 2 signed by PS
but it is
Rono.
PS Rono.
That is Rono, not
Yes.
Kipto.
To you. To you.
Yes.
Yeah,
So
to Rono.
where is that?
So that now, number 1, I'm in page 2 now.
Yes.
Where it says MSRL be allowed to import duty-free. Number 2, that such importation, be in full compliance to the Sugar Import, Export and Byproduct Regulations 2020.
Yeah, but this is a letter from Rono. It
Yes,
doesn't have
but
to
he
be-
knows. The PS...
It's not from IPS.
No.
I thought you were talking of a letter from IPS.
What I'm trying to
I
say...
am not answerable to every fact that is written by PS Agriculture.
Allow me, Chair, to prosecute my point, then the CS can respond, because I don't think we are in an exchange scenario. So my point is that the PS is writing to National Treasury and saying, give authority to waive import duty on this item for as long as it is going to comply with the Sugar Import, Export and Byproduct Regulations 2020, which regulation the PS for Agriculture is fully aware that raw sugar is not already in that regulation because the regulation had not been done. So that's why I'm saying that the CS, because the CS said that he relied on this letter and the letter from State Department for Industry, which letter for industry was talk about duty remissions committee to talk about public interest, that he relied on letters that he needed to have looked at what that regulation said for him to be able to do public interest.
Chair, letters come from State Departments and they mention everything. Sometimes they even quote wrong laws. But we respond based on the law. The letter from the National Treasury has not mentioned that regulation. If we find what you have mentioned in the letter does not make sense, we ignore it and we base on the law. So I thought you are referring to my PS, referring to a regulation that does not exist, and that I would take responsibility on his behalf and on behalf of the ministry. But we responded, and if you look at the letter from PS National Treasury, we quoted the laws that exist.
CS, can we give you the regulations just a minute so that you look at, we see, you get the point where the members are asking.
But I think, Chairman, maybe you are also not getting what I'm saying.
Yes.
Who has quoted regulation? Is the PS Agriculture. You can ask her which regulation is this that he was quoting. For us, we ignore. If there is no regulation, we ignore that.
Chair, I have a lot of respect. I have a lot of respect to CS Mbadi. But in your statement, you have considered that part of the reason why you thought public participation, public interest sufficed was the recommendation by the Department of Agriculture and Ministry of Meat. So if this is a letter that you relied upon to make a decision on public interest, I don't think this is the right time to disown it, because now you considered it as part of the, alongside other things, including your own thinking. That is one. Finally, Chair, because I don't want to take much time, I believe there was a good reason. There was a good reason to have the factory relocated from Kisumu to Mombasa, because it is in your document, because that appears to be part of the consideration. What was the rationale of considering this refinery from raw sugar to industrial sugar in Mombasa and not in Kisumu? I think you can shed some light on that, so that we can now start establishing whether there is a refinery in Kisumu or in Mombasa on this industrial sugar.
CS, his question is from your bar graph number 12. Where you say your approval relied on the decision took into account the application by Mombasa Sugar Refinery Limited, the recommendation of the Ministry of Agriculture and Livestock Development, and the Ministry of Investment, Trade and Industry. Yes. That is where I think that question is coming from.
Chair, let me put it this way. These are the things that the PS said was just talking about procedure. Mine is a policy, and look at where I drew my policy from. In conclusion, and noting the role of the government is to facilitate manufacturing under the economic pillar of the bottom-up economic transformation agenda. So my policy is to promote investment. If the PS made a mistake of quoting regulations that don't speak to raw sugar, it is not my mistake. It is the PS to be asked, why did you quote a policy or regulation that doesn't exist? And I have spelled here clearly that there is no suspension of that law awaiting regulations. I have legislated in Parliament, and there is nowhere where there is suspension of the public interest until regulations are done. If there is, pointed out to me. I have not seen it. And so, if you could allow me, then I address other issues. Because I think this matter, I have put across what I think I would respond to, unless there is an answer that someone is looking for, which I don't have. So, Chairman, it is simple, in my view. I was called here to talk about tax policy. The law allows me, even tomorrow, to give tax exemptions. If that responsibility is taken away by Parliament, I will oblige and I will respect. But so long as still I have it, I will exercise my mind and thoughts to it. And on this matter, bearing in mind that this, first, the question we need to ask ourselves, do we need industrial sugar in this country? The answer is yes. Do we have enough? Do we produce enough? The answer is no. We import finished product of industrial sugar to use locally. And someone asked me, one of the honorable members asked, the local sugar. It is in this letter from Principal Secretary in charge of Agriculture and Livestock Development and State Management for Crop Development. He said currently, local sugar is used for domestic purposes and rarely meets demand. So there is none for industrial use. Technical officers from the Agriculture and Food Authority, Sugar Directorate, have inspected the refinery and ascertained that the refinery was complete with all equipment. Therefore, we have a factory here established to process further raw sugar into finished products so that we don't import finished industrial sugar. And I'm asked to exempt RDL and IDF, and I'm being told that is not in public interest. I don't know then what is in public interest. Because if this factory is going to create jobs, if this factory is going to ensure that we don't import wholly finished products, that we will subject it to further processing, I believe that is public interest. And I don't have to wait for any regulation, unless The law is explicit that there must be regulation to govern this, and there is none. And probably this legislation was done when I was in Parliament. You know that? And I didn't see it fit to add that proviso. So why should I apply a proviso that doesn't exist?
Chair, fine. I think the elephant in the house was the procedure used to determine public interest. And I think we have flogged the horse sufficiently, and I would agree with me. I personally am not convinced that the Cabinet Secretary applied due diligence in determining and arriving that is...
Dr. Undo, that you know very well, we shall determine.
I want to put it on record.
Yeah.
Thank you.
We shall determine.
But Chair, can I just respond? Do you know this issue of public interest and public participation has not been resolved in this country? You need to legislate. You have not legislated. I was in Parliament, we never legislated. Public participation needs to be legislated. You cannot hold me here on a parameter that is not defined. Chair, it is not fair. I have been in Parliament for years, for donkey years, 17.
Let's listen to the CS.
Court cannot legislate.
Proceed, then
Supreme Court can only give direction on how to do it. Parliament is yet to legislate on public participation, and the bill is with the Attorney General. I even know the draft bill. Legislate first, then hold me to account on a threshold that is provided in law. Otherwise, it will be a fishing expedition.
Yes, proceed.
I think I responded to one of Parasina on this issue of safety of Kenyans. It would be very disheartening for me if the people of Kenya would be subjected to bad sugar. In fact, the sugar that you referred to, that was imported that time, which was contaminated, was for domestic use. It was table sugar. This was industrial sugar. And my understanding is industrial sugar should be subjected for further processing to industrial sugar. And the truth is, we need industrial sugar in this country, and it is not being refined here. This is probably the first refinery. And on that basis, I felt this was important business. This is important investment to support. One of us again asked why we are applying public interest in a private company. There is no law that says public interest can only go or be considered in public companies. I am one person who believes that we don't need public companies to be involved in business. It's the private sector. One way of promoting private sector is to support their investment by giving them duty remissions, by giving them tax exemption that would promote the investment. That is how to attract investment in our country. Why this company has not operated from 2014, I don't know. Honestly, I have no idea. I can only speculate and rumor, maybe get involved in rumor mongering. I think I've addressed raw sugar versus table sugar. Whether this, you see, the law allows raw sugar also to be imported in this country. And on that basis, it is known that it resembles table sugar. But there's a procedure. And that procedure, I did not say in my letter, approving exemption, that anybody violates those procedures. So the procedures are still in place. Anyone who violates those procedures is committing a crime. I have not committed a crime. I have only applied, given exemption for RDL and IDF, as the law provides. Where I did not have powers like VAT, I vacated it. I said, no, this one I cannot. This one I can. But in strict compliance with the law. And everybody must follow that law. I think, Honorable Kamene, it is not through the chair. It is not correct that everything is organized at the Treasury. How? How was everything organized at the Treasury? I get requests for approval of exemption. RDL, IDF. I got that request. I acted. The other organs and agencies kick in now to ensure that all the procedures are followed to the end. Where is it? Is there any letter where I instructed anybody, any agency, not to play their role? None. I only gave exemption. And I think the question, the dispute here, to me was small, where maybe a few of us felt that they differ with me, which is allowed. That did I apply my mind correctly in terms of public interest? That is the only question that I should address. And I say, as far as I'm concerned, Chairman, I address myself public interest because there's no factory, refinery in this country, refining raw sugar into finished product. We are encouraging that we should not be a country that imports all finished products. Where we can import partially finished products and process them further is better than nil. And that is exactly what we are doing. If we could process the whole raw material from sugarcane to industrial sugar, the better. But if we don't have local production that would support that we have to import raw sugar. So long as we can import it unfinished and process it further, to me that is public interest. And I don't think anyone can convince me that that is not public interest. But I have no monopoly of ideas. Someone can have a different thought. I have my own thinking. That this, to me, fulfilled the threshold and the requirement that this was public
Consider that
interest.
point, we have taken too much time on it. Yeah, we have taken too much time on it, and we are just repeating ourselves in the same manner. So I think you move on to another issue. Now,
the relocation aspect, was it a consideration? The relocation of the factory from Kisumu to Mombasa, what would have been the rationale to have it in Mombasa, not in Kisumu, as you've indicated there was meant to be a relocation?
Mr. Chairman, I can only speculate. Maybe they were moving closer to the port of entry. I can only speculate. But since Mombasa is in Kenya, as Kisumu is in Kenya, I had no problem. If they moved to Tanga.
Waziri, the way you are answering us is not fair. Because we are moving a company from Kisumu, taking it to the port, inside the port. That means there is a reason for it, which you must be aware. Maybe you are securing your taxes, you don't need to go through multi-agency things and so on. To simply say that, it's a bit...
No, Chairman, honestly, it was not us who moved this factory. It was the business person, the industrialist, who moved it to Mombasa. And that's why I said I can only speculate that probably because they wanted to be closer so that they don't incur transport expenses to go and process the same product in Kisumu.
So, Chair,
that is my thinking. But I am not speaking with authority on
through
this.
you, Chair, the way it is put is that the company indicated to you or informed you that they moved from Kisumu to Mombasa. They relocated. Is that the information that you have? Whether they did or not, because you are saying following the relocation of the refinery from Kisumu to Mombasa. Where is the source of that aspect that you said following? Is it the information that we have, they gave you, or how did you, it's your report, number 7, following the relocation.
Waziri, you are aware that these documents you have submitted to us are public documents now. They'll form part of the report. Because when you say you have following the relocation, that means the factory has relocated to Mombasa. If I may understand the way. Yes. Where in Mombasa is this factory relocated to?
No, Chairman. First of all, if you read that,
because it's upon relocation and change of name that they applied for exemption of import declaration fee and dairy development levy. And subsequently, approval was given. You know, that if you look at that statement, there was relocation and there was change of name preceding the approval.
Which was corroborated by the relevant ministries, the State Department for Agriculture, and also Ministry of Investment, Trade and Industry, which are responsible for all the procedures of licensing and location. You know, I could not go and check whether physically the factory moved from Kisumu to Mombasa.
Yes, okay, I agree. He cannot go, but was there any communication that there is relocation, and what was the source of that information? You know, we would not expect you to go in every other place to verify, but that information is relevant to this committee.
If that is the information that this committee requires, we'll provide it. I'll get the information on the letter that addressed the issue of relocation. Yes.
Okay.
Chair.
Yes.
Chair, the CS needs to be aware of provision of Article 2 to 3 that clears bounds all public officers to be factual and committed to public service. And allow me, because this report he has submitted here, he has submitted under his own signature. So whatever information he has been given, he has checked and verified and proved they are correct. The matter is at his signature, it ceases to be information given by third party. It now becomes primary evidence for us. It's not third party. And surely, Honorable Speaker, Chair, because the Article 233 clearly says that a public officer, values of public service include high standards of professional ethics, efficient, effective, and economic use of resources. But most importantly is the issue transparent and provision to public of timely, accurate information. By the time he agreed to come and present here, we take these details, this report, being timely and accurate information. If the information provided here turns out to be wrong, or is wrong information, then he has breached the provision of the Constitution. Either the Cabinet Secretary say, would rather go and withdraw this presentation, go verify and present a verified report, or we take it and then we leave the public court to decide.
Chairman, let me just address this issue. There's no reason to doubt that this factory had relocated to Mombasa. The letterheads and everything else is Mombasa. But above all, Chairman, above all, I've been given a document here. There's no contradiction. Where in November 2023, the name changed from Kibos to Mombasa. It was even from this committee. So why should I be asked when I state that in 2025, the factory had changed the name to Mombasa, unless someone is on a fishing expedition? I have answered all the questions, Mr. Chairman. I think now we are going around in cycles. This company changed, the factory changed from Kibos, and you're the ones who have given me a document here, unless you are also telling me, Chairman, that this document is not factual.
No,
so
we are discussing your
changed.
report. We are discussing your report.
So what I said is that there is no, that letter, it's like I was asked a specific communication. And I said, if that communication is not here, I'll get the communication. That does not amount to what I presented not being factual. And you know, I own everything that I signed. An honorable owner knows that. I cannot run away from my document.
Chair,
but
CS
is
is
it
right.
trying to
Order members.
Yeah, through you, Chair. CS is right to the extent that there was a change of name. But the issue of relocation does not go with the name. Even if it's called Mombasa Refineries, if they never relocated, we have a reason why we are asking that. And I think that information is very, very important because
on that
they
one,
may have lied to you, and that is what we want to know.
Order members, order. I think the CS already has answered that, and he said he's going to provide information on that. Are we? That is clear. He has already answered. We can't go back to that. Yeah, let us be brief. You look at your time, and we need to close. Yeah. Let's not go into stories now.
Thank you, Chair.
We need to conclude.
CS. Yes, I'm the one who asked why those people they have taken for 12 years without working for that factory. CS, I don't know whether you have checked whether those people they have tried to apply from the state agency to get a letter to import low sugar. They have tried before. If they have tried before, they have not given the letter to apply. Does it mean there was risk with this low sugar? Why they are not getting a letter to import that low sugar? Maybe there was risk that we are not getting those this letter to import that low sugar. That's why I was asking, why have they taken investment of that magnitude, 12 years without working?
That one he answered. He said is that and no. I think CS, we need to close. Yes. You want to inform who?
I want to inform my colleague.
Okay.
Yeah.
Do you want to be informed?
I want to inform him that, and even just my colleague, in due respect, that I think you chair tunachoka. We are becoming so tired. Yeah, there's something I'm bringing the information. We are becoming tired because basically I can share information on who is disturbing this sugar. So that we save the country from run up and down, all the work and help my colleague.
Honorable member, if we are tired, nothing stops us from summoning requesting the CS to come again. So I want us members, order. Order, Waziri, you have an advantage because
Chair,
you've been to both sides.
Needs to be substantiated because I come here and I have an integrity to protect. I cannot protect.
That's why I'm protecting you. That is why I ruled out.
So if you knew who has imported the sugar, there was no need of calling me. You would have just provided that information.
CS, you are responding to matters which have not come to you. I already protected you, and I said, I ruled on that. You have an advantage because you have been on both sides. We've not been on the other side. Yeah, so, CS, I think with that information where we reached today, of course, you've seen there are still more concerns. We have questions which we have issues which are unresolved with KRA. They were before us. They have given us contradicting reports. They are supposed to have responded to our specific questions by yesterday. 7 days have expired. And we are just talking about KRA because they are under your ministry. Yeah, they are under your ministry. So there's quite a lot hanging. So far, we've done very well. We are happy. You've given us a lot of information, and several things have been learned. You have also engaged us properly. We feel if there is more information, because the public need to know and be educated on certain issues, and where they feel there is shortfall, we stand accountable on it. Otherwise, thank you. This is the first time you appeared before this committee. You are welcome any other time, either by our invitation or even on your side. You can always, he can invite us for a retreat for whatever matter. We make laws for him. Yeah, we make business laws and so on. There's quite a lot. Yes. Yeah. So, Waziri, you can give your closing remarks.
Thank you, Chairman. I'm very grateful for appearing here and shedding light, and I appreciate the depth of interrogation on this matter. just to mention that we do policies to guide our agencies. And KRA, if I was requested to come with them, I would have actually come with them, because the information I had was that they had appeared before this committee. But I would have come with KRA to address. Otherwise, I will find out why they have not responded to request for information from this committee, because they have a duty and a responsibility to do that. I want to just thank you once again, and maybe not really for record. It is true, Honorable Undo has been my friend. But since I left him in Bunge, I'm a Rebecca, so I don't know what to do. I may need to come back to Bunge to still shape him. But anyway, with that is
Waziri, you know that is on Hansard. Huh?
I hope Hansard has been stopped. Please
withdraw that from the Hansard, then you can talk that off the record.
Was the loud touch. I withdraw it completely, Chairman, if it's captured by Hansard, and maybe to switch off the mic.